Bonjour, bienvenue. My name is Colin, Carrie, Member of Parliament for Oshawa. Good morning. I'm joined today by Ms. Lisa Freeman. Lisa Freeman, an Oshawa-based victims' rights advocate, award recipient, and daughter of the late Roland Slingerland, an Oshawa resident who was bludgeoned by an axe murderer in 1991. I'm also joined today by Quebec Senator Pierre Boisvenu, also a victims' rights advocate, who will offer his comments and support for the legislation Bill C-320. The aim of Bill C-320 is twofold. One, amending current Canadian legislation to better meet the needs of victims of crime by providing timely and accurate information upon sentencing of an offender and avoiding the false comfort of misleading parole eligibility dates. And two, ensuring that victims of crime are provided with improved transparency and passage of information from the Correctional Services Canada and the Parole Board of Canada. Ms. Freeman is the author of the 2016 book, She Won't Be Silenced, the story of my father's murder and my struggle to find justice within the Parole Board of Canada. After years of fighting to have her family's voice heard as decisions were made about parole and the passage of information concerning her father's murderer, Ms. Freeman has petitioned the federal government to amend the ineffective Charter of Rights for Victims of Crime and the opaque Corrections and Conditional Release Act to provide improved transparency to victims and families of violent crime. And I invite Senator Boisvenu for his comments.
Thank you very much, Colin. Lisa, it's a great pleasure to see you again. C'est un honneur pour moi aujourd'hui d'être à côté de mon collègue, le député Colin Carrie, député de la circonscription d'Oshawa, pour défendre le projet de loi C-320. J'aimerais en premier lieu saluer la présence et le travail acharné d'une femme que j'admire beaucoup, Lisa Freeman, dont le père a été assassiné en 1991 et qui est à l'origine de ce projet de loi-là. Votre présence, Lisa, est très importante car vous portez la voix de nombreuses familles de victimes qui ont vécu et qui vivent la même situation que vous et qui ont ce sentiment qu'elles sont secondaires aux yeux du système de justice. Ce projet de loi modifiera la loi sur le système correctionnel et la remise en liberté sous conditions afin de prévoir une meilleure accessibilité pour les victimes et leurs familles aux informations concernant les libérations de criminels par la Commission de libération conditionnelle du Canada. Ces informations concernent les méthodes utilisées pour déterminer d'abord la date d'admissibilité et d'examen applicable aux délinquants relativement aux permissions de sortie, les placements à l'extérieur aux libérations conditionnelles et aux libérations d'office. C'est un projet de loi d'initiative citoyenne. L'assassin du père de Lisa a eu droit à une libération conditionnelle anticipée 5 ans avant la date d'admissibilité prévue au Code criminel, qui a pris Mme Freeman au dépourvu et qui l'a engagée dans ce combat. Afin de remédier à ce manque de transparence et de clarté de la part de la Commission de libération conditionnelle du Canada, ce projet de loi permettra aux familles d'avoir accès à toute information que la Charte des droits des victimes de criminels leur reconnaît. Est-ce que ce projet de loi vise un meilleur respect des familles de victimes? Plus encore. Ce projet de loi fait en sorte que le respect de la Charte des droits des victimes de criminels soit respecté par la Commission de libération conditionnelle, aussi bien que le Service correctionnel du Canada. Je le rappelle, c'est une loi fédérale adoptée en 2015. De nombreux témoignages qui me parviennent de dizaines de familles attestent que aussi bien la Commission de libération conditionnelle que le Service correctionnel ne les informent pas correctement du déroulement des audiences, des décisions qui ont été prises et des dates qui sont déterminées. Quand ce n'est qu'elles ne sont tout simplement pas informées. On l'a constaté cette semaine lors du transfert du plus cruel assassin du Canada sans que la famille n'ait été informée au préalable. Ce manque de respect envers les familles est inacceptable. Pourtant, comme je viens de l'affirmer, ce droit à l'information est ensaché dans une loi canadienne qui est supraconstitutionnelle, donc au-dessus de la Commission de libération conditionnelle, au-dessus du Service correctionnel, au-dessus de la GRC. C'est une loi supraconstitutionnelle. En effet, au paragraphe 8 de la Charte canadienne des droits des victimes, elle garantit ce droit à l'information à ces familles. La Commission de libération conditionnelle du Canada doit respecter cette loi. Il est temps, à présent, d'entamer une réforme de la Commission, car depuis de trop nombreuses années, trop de décisions ont affaibli la confiance des victimes et de la population générale envers cette institution. Ce projet de loi est un pas en avant. J'aimerais remercier mon collègue Colin Carrie pour son attachement aux droits des victimes et j'espère que tous les députés de la Chambre des communes appuieront unanimement ce projet de loi afin de faire avancer cette importante législation. Merci. Alors, je laisserai la parole à Mme Freeman. Lisa.
Thank you, Senator. Thank you, Mr. Carrie. My name is Lisa Freeman, and I am the daughter of a murder victim. I grew up in Oshawa, Ontario, and continue to live and work there today. I'm also an author and advocate for victims' rights and criminal justice reform. I've worked to share my story and my murdered father's legacy with legislators, advocates, and the public over the last 3 decades. My sincere thanks to the national French and English media, as well as our local media outlets, for your time and attention today. Canada's justice and parole systems use various words to imply severity or to imply punishment. To a passing observer, the language that these systems use to describe sentencing or punishment includes words such as severe and harsh. For example, the term life in prison with no parole for 25 years is a complete misnomer and falsehood. That phrase gives false comfort to the offender's victims and their families and provides false information and assurances to the law-abiding Canadian public. These are merely words uttered by judges and often echoed by the media. Here's the reality. Offenders serving a life sentence with no parole for 25 years are, in many cases, actually released on other forms of parole as early as the 22-year mark of their sentences to pursue personal development. Temporary absences from prisons are often granted to perform community service work and, we're often told, only undertaken in exceptional circumstances. However, these aren't exceptional or isolated incidents, and the result for many victims' families, like mine, is more trauma, emotional pain, and endless concern about our own family's safety. In prisons across Canada, offenders who have committed capital crimes, including murder, are too often housed in minimum or medium security prisons. In fact, we learned just last week that one of Canada's most heinous criminals, a vile rapist and murderer, was moved from a maximum security prison in Eastern Ontario to a medium security facility in Quebec. In this killer's case, just like my late father's axe murderer, the level of prison security in no way matches the severity of the crimes committed by these wicked individuals. When axe murderer John Terry Porter bludgeoned my father to death in 1991, I was just 21 at the time. He received a life sentence. When he was convicted in June 1992, the Toronto Sun headline read, "Hatchet Killer Jailed for Life." What a joke. A complete charade and a fantasy, we would soon find out. Terry Porter is an axe murderer. He is a vile individual. He was supposed to be locked away from society and serve a long sentence for the cold-blooded bludgeoning of my father, a kind and gentle man who worked as a caretaker at a rooming house. Never did I think that this killer's sentence would include such luxuries as he receives today at his halfway house. The ability to secure paid employment and own a car, with a roof over his head, and best of all, catered meals made by his halfway house's chef. Most law-abiding and hard-working Canadians don't live as well as my father's killer. In recent years, my father's murderer was moved across the country to Alberta because the program he wanted to attend was not available in Ontario. But here's the problem. The killer's transfer out of Ontario would place him in an institution that was just situated just 10 kilometers from my sister's home. You heard that right, just 10 kilometers from the victim's daughter, my sister. Worse, the parole board only notified me 24 hours after the killer's transfer had occurred. According to the board, this convicted murderer had the right to delay the information by 1 day. Neither the criminal nor the board should have any right to delay the immediate sharing of this information with victims or their families. This is just one problem, a serious one. Now here's another. In April 2020, just 20 years into his sentence, my father's killer became eligible for early parole. Under the current provisions of the Corrections and Conditional Release Act, a criminal has the right to an in-office hearing and a decision on their request once they have passed their parole eligibility date. I was told that due to COVID-19 restrictions in place at the time, I would be denied the ability to attend the hearing, either in person or by video conference. A few months later, in October 2020, I was denied the opportunity to participate in a second hearing. Had I been able to attend one or both of these hearings, even through a video conference, which during the pandemic was how most of us did business, I would have delivered a victim impact statement detailing how my father's murder had impacted the lives of our family. I would have told the board what it has been like for us to live with the impact of my father's murder over many years. To my shock, but not to my surprise, the axe murderer was granted day parole at this second hearing in October 2020. But to make matters even worse, I learned that the decision to grant parole was undertaken by just one member of the board, not a panel of individuals who together would judge his suitability for parole. I was denied the opportunity to participate in both of the killer's 2020 hearings, either in person or by video conference. No video conference option was even offered. I was appalled. To be perfectly clear, it was not COVID-19 or the global pandemic which denied me the right to attend these hearings. Rather, it was the parole board itself that denied my right, simply because they could. The families of murder victims shouldn't be subjected to this type of treatment, because we are busy people. We're busy grieving, busy trying to repair broken lives, and busy trying to keep the lifelong emotional trauma at bay. The actions, decisions, and policies of both Correctional Services Canada and the Parole Board only serve to re-traumatize survivors, victims, and their families. It is us who must, on a regular basis, interface with Correctional Services or the Board at our own expense and on our own time. We must navigate our way through this country's broken justice system. It's ironic, isn't it? While it's supposed to be a job of Correctional Services, the Parole Board, and our justice system to ensure that dangerous offenders are kept behind bars, the system is failing miserably. From plea deals and watered, broken-down sentences for violent crimes to issues with the Parole Board, this country's justice system continues to put the rights of violent offenders ahead of their victims and survivors. We've got it backwards. With the help of my Member of Parliament in Oshawa, Colin Carrie, we're taking a crucial step to shore up victims' rights. Specifically, Mr. Carrie's legislation would accomplish two aims. First, we want to ensure that there is no delay in sharing of critical information about an offender's movements or the relocation to another prison or facility with their victims or their families whose lives they've ruined. Second, we would want to ensure that victims of violent crimes are not denied their right to participate in a criminal's parole board hearing, no matter the circumstance, be it during a pandemic or for some other reason that the board alone may offer. Back in 2019, Mr. Carrie had introduced a similar bill, Bill C-219, in the House of Commons. It received significant support from members right across the party lines. But when the Prime Minister called the 43rd general election in the fall of 2019, Mr. Carrie's bill died on the order paper. This year, with the assistance of his Senate colleagues, Senator Pierre-Boisvenu, Colin again has introduced similar legislation, now known as Bill C-320. It's our second bid to have the victim's right to information enshrined into the Canadian Victim Bill of Rights. This is what is at the heart of Bill C-320. I'm confident that these small but significant legislative changes will help put victims' families one step closer to being accorded timely information and the right to be fully informed about an offender's status and movements. Victims expect and deserve nothing less. This legislation is a key step that will, I hope, lead to many more necessary reforms at the Parole Board, including safeguards which prevent the board from excluding victims from parole hearings. The Parole Board of Canada has twice denied me any ability to participate in holding my father accountable for his actions. I will continue to work to hold the board accountable for re-traumatizing our family. These past decades have been incredibly difficult for us. Although Bill C-320 will not solve all of the issues that frustrate victims of violent crime, I believe that the bill's provisions are reasonable and mark an important and long overdue step. I believe that Canadians, including my own family, simply aren't safe these days. I'm truly grateful to Mr. Carrie and Senator Boisvenu for their efforts. I'd employ all MPs and senators of every stripe to come together and support this bill's passage into law. Let's make sure this effort doesn't die. Let's do what's best for victims, survivors, and their families. Thank you, everybody.
We're ready for questions. So if you have a question, you're online. Please use the raise hand function to notify us of your question. Si vous avez une question, vous êtes en ligne, utilisez la fonction lever la main pour nous faire part de votre question.
Thank you very much.
Thank you.
Thank you very much.